everyone. Thank you for joining us today for Navigating the Future. Is your company ready for the EU AI regulations? We are looking forward to an engaging and insightful discussion with a really all-star group of panelists and our moderators from MLA on this very timely topic. My name's Lauren Horan. I work in marketing for MLA, and I'm going to be your behind the scenes moderator for today's webinar. I just have a few housekeeping items to go over as people are starting to join the webinar. I will just quickly share with you that before we get started, all participants are on mute and their cameras are off. The webinar is going to be about 1 hour in length. We will have time at the end for Q&A. So that being said, we really encourage you to enter your questions in the Q&A section, which if you scroll to the bottom of your screen, you'll see a Q&A icon. Please, whatever you have questions about, anything and everything, just jot them down. We are really excited for this topic. We know there's going to be a lot of interesting questions and conversation. We'll do our very best to get to most of the questions. And as a reminder, this webinar is being recorded, and all registrants, whether you're able to attend live or not, will receive a recording of this webinar in their emails in the next few days. At the close of today's webinar, a quick survey, a couple questions will appear on screen. Just let us know how we did today, and if there's anything from the future topics you'd like us to cover, we would be happy to hear your feedback. So with that being said, I'm going to turn this over to my colleague, Jerry Temko, to get things started.
Lauren, thank you very much. I'm Jerry Temko, Managing Director in the London office at MLA's in-house recruitment practice, and together with my dear colleague, Pam Salling, who is Managing Director in MLA's Basking Ridge, New Jersey office, we'd like to thank you all for joining us today for this important webinar on the implementation of the EU AI Act. As you all know, the role of artificial intelligence in our society continues to grow exponentially. But with this growth comes the responsibility to ensure that AI systems are developed and used in a manner that is ethical, transparent, and beneficial for all. The Act represents a significant step forward in regulating AI technologies, and it aims to create a framework that fosters innovation while safeguarding fundamental rights and values. And so today we will explore the key aspects of the Act, from its risk-based classifications of AI systems to the obligations that it imposes on developers and users, the Act's territorial scope, its impact on HR compliance and legal operations, the General Counsel's role in AI governance, and crucially, talent readiness and the AI skills gap. Pam?
Thanks, Jerry. We've assembled the most wonderful group of panelists today. They're going to give us an overview of the AI Act. This is going to be everything from risk-based classification to the obligations it imposes on both developers and users. They're going to give us some practical tips on how we can be compliant, common HR and compliance tools, what we should be prioritizing between now and 2026, what is the General Counsel's role in AI governance, what kinds of legal and compliance skills are going to be most sought as AI regulation ramps up? And how can legal teams build AI fluency internally without having to rely solely on external counsel and external consultants? Jerry, could you introduce our panelists?
Thanks, Pam. We're very fortunate today to have the participation of 3 leading practitioners in the field. Zina Hatzidimitriadou is a senior managing associate in the healthcare, biopharma, and medtech reg practice in the London office of Sidley Austin. She is experienced in representing both Fortune 100 healthcare and life science companies, as well as small biotech, medtech, and digital health companies. Her practice focuses on regulatory law, including strategic litigation and pricing and reimbursement matters before national and EU authorities and courts. She's been actively engaged in delivering AI and digital health transformation projects to biopharma and medtech companies. Catherine Robinson is head of legal at Protex AI with a background in AI, technology, computer vision, and life sciences. She has global experience with enterprise SaaS, AI-enabled medical devices, AI drug discovery, and AI cybersecurity. And she's worked at Isomorphic Labs, Illumina, and Darktrace. Protex AI is an AI-powered workplace safety and operations platform. It helps enterprises monitor and respond to safety and operational events in physical environments through real-time video, analytics, and contextual insights powered by computer vision and machine learning. And finally, Sharat Naki is Principal IP Counsel and IP Lead AI and Digital at Novartis, focusing on steering intellectual property strategies for AI and digital initiatives. And he also manages complex litigation and develops robust IP portfolios for Novartis's pioneering rare disease treatments, including gene therapies and biologics. Thank you all once again for being here. And let's dive into the EU AI Act. Pam, over to you.
Perfect. Let's do it. I want to know the basics. What are the key components of the EU AI Act that legal teams need to be aware of today?
Thank you, Pam. I'll take that. And it's no secret that the AI Act is regarded as the world's first comprehensive regulatory framework for AI. It does adopt a risk-based model to the classification of AI systems, and it started applying already on the 1st of August 2024. So we will assume some basic knowledge and won't get into very granular details. I'm sure all of us are happy to do so or helpful, but we will be giving some more practical insights. And I would say, in short, there are about 6 categories that I would classify as key components that legal teams need to be aware of. The first one is the material scope. In other words, what is an AI system that falls within the remit of the AI Act? And on this slide, we have the definition. As you will see, it could be and it will be subject to some ambiguity, even though the EU Commission has recently published some guidelines assisting companies to determine what is an AI system under the law. Now, the second point is the risk-based approach that follows in the Act. In other words, AI systems are classified by risk level. We have at the top of the pyramid the unacceptable risk. In other words, AI systems that would never be allowed to be used in the EU. Then we have the high risk, limited, and minimal risk uses. And really, the main burden of the regulatory obligations focuses on high risk AI systems. Just to know that general purpose AI systems are outside of this classification. The third point to bear in mind has to do with the timelines and the transitional periods. There is a staggered application of different provisions, and although there are discussions at the moment on a potential postponement of some provisions or stop the clock about the high risk requirements in particular, it is far from certain that this will happen. So companies really have to start preparing now for all the obligations that are due to become applicable. The fourth component to bear in mind is the fact that obligations on companies vary by role. What this means is that companies that are providers, in other words, developers of AI systems, will have different obligations, harsher obligations than deployers or users of AI systems. And then we also have obligations on importers and distributors, although those are much lighter. The fifth element is everybody's dreaded category of enforcement and fines. And on the third slide, we have a summary of some main aspects and provisions that you can read at your own time. But really, what is important to note here is that enforcement is delegated to national authorities who are coordinated by a centralized European AI office. And the fines themselves are also quite significant. They can reach up to 35 million euros or 7% of the global annual turnover for most serious breaches. So companies need to be aware of their governance and maintain documentation also for potential regulatory audits. And the sixth element to keep in mind for legal teams is that the AI Act is a consumer protection law, but it interacts with a lot of other pieces of EU legislation. So it's complementary to the GDPR and the new Digital Services Act and Digital Markets Act. And legal teams have to ensure that their AI compliance is aligned with all these different pieces of EU law and be mindful of overlapping enforcement actions across regulators.
Thanks for sharing those components. It's really helpful to set the table.
So, Zena, what's the compliance timeline and what should teams prioritize between now and the 2026 deadline?
Yes, a good point. Also, because we have a staggered application of the various provisions, Jerry. So already on the 2nd of February 2025, we had the first wave of obligations that started applying, and those relate to prohibited AI practices and AI literacy obligations. Now, in just over 2 weeks' time, we'll have a new layer of obligations, and those relate to governance rules and the obligations for general purpose AI models. Those include foundation models, open source deployments, API-based systems, and so on. And there was discussion about those being postponed, but we now have a confirmation that this will in fact apply on the 2nd of August. Mm-hmm. Then the main set of obligations under the AI Act will become applicable next August 2026, and that will see enforcement beginning for high-risk systems across sectors that include healthcare, human resources, law enforcement, education, and finance. And then we have a little exception for August 2027, and those concern obligations for high-risk AI systems that were already in use before the Act became fully applicable. And they have one additional year as a grace period, I guess. What does this mean in practice for teams? What should they prioritize between now and 2026? Well, the first bucket of obligations that is already applicable has to do with prohibited AI practices. So companies must make sure that any AI uses that might use social scoring, that might be manipulating or exploiting people according to the definition of the Act and pose an unacceptable risk are already not used. They must be stopped or changed immediately. Then also AI literacy applies. There is no clear prescriptive list of what that might entail, but in practice, it's the obligation to educate all teams as to the applicable risk, the applicable responsibilities of using AI systems, but also understanding how AI works. And that's very much a living process. It has to be maintained, kept up to date. There are quite a few people in the audience I know who are implementing AI literacy. So you will know that this obligation can be quite difficult, in fact, to comply with, and it could be a lot of work. Looking forward at the obligations that will kick in as of next year, the first priority will be to run an internal assessment, do a mapping of all AI systems held or used by the company, and identify the risk category to which they belong. And this audit will really enable the identification of what obligations will apply. Hand in hand with that is governance, and that will help guide the company to formulate internal policies and frameworks according to the risk of their AI systems, and those must be revised periodically. And again, putting those policies in place will be a teamwork, as we'll discuss a bit further on. Record maintenance, another point to keep in mind, is a key aspect in terms of implementing proper data storage policies already now is key to prevent loss of data and reducing compliance costs. And of course, stakeholder and third-party communications. Make sure that both consumers and business partners know how the organization is complying with the Act. This is key to building trust and assisting long-term success, because the AI Act is not meant to be a punitive piece of law. It's meant to enhance the way AI is seen and improve trust in using AI solutions. And so it will be the companies gain and benefit if they can already do this with their partners. So in a nutshell, I think that's what I would say as some priorities to look at.
Sounds like the 12 labors of Hercules, Zena. It sounds like quite a burden. How would you say, how far does the EU AI territorial scope actually reach? Does it apply to non-EU companies?
It does indeed. And no matter the size of a company, the minute a company is building or deploying AI that touches EU users, they will be in scope of the Act. And again, this is construed very broadly. The company doesn't even need to intend for their AI system to be used in the EU. The minute the system affects EU citizens, it's brought within scope, and that could concern either the system being placed on the market or put into service in the EU, regardless of the location of the provider. But it also concerns any AI systems somehow used to affect EU citizens. So a very broad and extraterritorial reach of the Act.
So we have to capture hearts and minds outside of Europe.
Well, hopefully, yes. Hopefully hearts and not just fear.
No, that's fine. Pam, over to you.
All right, well, as someone outside the EU, I guess I could take this now that I know that it applies to me too.
Yeah.
As an executive search consultant, I'm definitely interested in how this act interacts with HR. But I suspect that since all companies have people and all legal leaders organize or manage people and HR issues, this is something on everyone's mind. So, Catherine, what are the common HR and compliance tools that are considered high risk?
So the Act will have very concrete effects on AI use cases in HR, compliance, and legal ops. So under the AI Act's risk framework, many HR-related applications are considered high risk. For example, using AI for recruiting or to make HR decisions about employees is explicitly listed as a high-risk use case because these tools can significantly affect people's careers and their rights. So that means if a company uses an AI-driven hiring platform or an employee monitoring algorithm, it must implement strict measures. So think rigorous bias testing, transparency with candidates or staff about the AI's use, maintaining detailed technical documentation, and possibly undergoing conformity assessments or registering the system with EU authorities. In fact, some AI practices in HR are outright prohibited by the Act. So a prime example is any AI that attempts to do emotional or biometric surveillance on employees. So like an using AI emotion recognition to gauge workers' mood, for example. Such uses are banned as unacceptable risk. So companies will need to avoid or disable those features entirely. And then for compliance and legal operations, the impact depends on how these tools are used. Compliance departments may use AI for things like fraud detection, regulatory compliance monitoring, or reviewing transactions for risks. If those AI systems could significantly affect individuals, for instance, an AI that flags transactions and might freeze a customer's account that could impact their rights, they may also be deemed high risk, warranting similar controls and oversight. Legal operations tools, say an AI that helps review contracts or predict litigation outcomes, might generally fall under lower risk categories since they aid internal decisions and don't automatically impose decisions on individuals. However, even lower risk AI applications have transparency obligations under the Act. The practical upshot is that companies should inventory all AI tools used across the organization and classify their risk levels. High-risk tools will need new governance, so human oversight mechanisms, data quality checks, record keeping, and perhaps an EU conformity assessment. Even for lower-risk AI, companies should set internal use policies and really sense check their transparency policies. In short, the Act pushes organizations to be more deliberate and transparent about how they use AI in day-to-day operations.
So when I think about that level of risk and the assessment that goes with that, it begs the question of, will this act evolve the role of the General Counsel? And if so, how does the role of the General Counsel evolve? I'd love to hear from all of you on that because I'm interested in your different points of view.
Thank you, Pam. Well, as an external advisor, I can chime in before the people actually doing it on the ground tell us their perspective. I would say that we just keep an ever-expanding role of a general counsel, and the general counsel in the era of AI will not be necessarily the person doing, but the person overseeing and having the general direction of how the pieces fit in together. So who will be responsible for AI implementation? We see companies outsourcing this to the new role of a chief AI officer, but inevitably this is a cross-functional role. It's an interdisciplinary task force that really necessitates pulling together different corporate functions, having someone driving this, but getting the right people together is key. And what is right may look different in each case. So we would expect to see people from legal, privacy, but also commercial, engineering, marketing teams, HR, security really has to be a team effort and a very much sort of living effort. Now, in terms of what, the General Counsel will have to have the, bird's eye view on what's happening. So the General Counsel will really need to be able to identify at any point what AI applications the business has, but also what training data is used and where it comes from, so that they can identify potential issues such as ownership and copyright, which increasingly become hot potatoes in the area of AI. And then hand in hand with that comes the question of who is doing what. A lot of the times we see third parties being involved in developing an AI program or system that a company is using. And so that means that liability could be tricky to determine. So who assumes what responsibilities, or what responsibilities are delegated to whom, must be mapped out so that there are no things, falling through the cracks when it comes to it. And the last point I would add about, the role of the General Counsel is keeping it fresh. It's not a kind of checkbox list that you do and get it out of your way, especially with AI. With AI literacy, we see that it needs to be kept up to date. Business partners, as they come on, need to be educated. We need to see agile policies, and we need to see a practical approach. So not, the lawyer locked up in the room giving directions, but a team member and a team captain bringing it all together, I would say.
Yeah, thanks, Sina. And I do find myself acting as a bridge between the technical and engineering teams and then the legal and the regulatory world. So on one hand, I find I need to understand enough about how our machine learning models work, not to code them, because that probably wouldn't end well, but to ask the right questions and spot potential issues, such as potential bias or lack of transparency early. And then on the other hand, I need to translate the regulatory expectations for our tech teams. So, for example, I'll interpret what appropriate human oversight means in practical terms for our product, or what documentation we need to maintain to satisfy the Act as a provider of an AI system. I've helped form an internal AI governance committee that includes representatives from engineering, product, data ops, security, and of course, legal compliance. We meet regularly to review AI projects and ensure we're all aligned on risk management. So I would say being a GC now, especially at an AI-focused company, means being much more hands-on with technology and playing a strategic role in guiding how the company innovates safely. It's an expansion of the skill set. So part lawyer, part risk manager, as we all know, but also part tech translator. So I'd say it broadens the GC's role to strategic decision-making about technology adoption.
Thanks, Catherine. So, being in-house IP counsel, and first, I just want to mention that I'm speaking in my personal capacity and not, representing Novartis here. So, one aspect that I focus on is the tension between transparency and intellectual property when complying with the AI Act. So the Act requires a certain degree of transparency about how AI systems work or what data they might use, particularly as for high-risk systems. But as lawyers, we have to find a way to comply with those transparency obligations. So, for example, providing documentation to regulators and users without necessarily exposing our secret sauce. That's a tricky balance, and we might have to disclose just enough information to be compliant and build trust. But we still have to protect our competitive algorithms and data. As particularly in the pharma industry, data is our most sort of valuable asset. So the in-house legal team plays a key role in striking that balance, and often by developing sort of careful disclosure strategies, as what to reveal, what to protect under confidentiality. I'm also engaging with regulators if needed to clarify how to protect IP when complying.
I think another evolving responsibility for GCs is in guiding ethical AI use. So, in pharma, for example, reputational risk is huge. So if an AI system was used that, say, inadvertently discriminated against certain patients or produced flawed results affecting patient safety, the fallout would be serious. So it isn't just about looking at black letter law. We also need to ask ethical questions and not be afraid to say no to AI projects that pose too much risk. So GCs are becoming educators. But I do want to emphasize, as Zina alluded to earlier, that the AI compliance is a team effort. It's not just the legal team's job. And even though in many organizations, legal is coordinating it, or at least a key stakeholder, it is important that you're bringing others in your organization along the journey with you. So as we know, a GC has always needed to wear multiple hats, legal expert, risk strategist, policy advocate. But as I mentioned earlier, that expansion to tech counselor is an interesting one. It's challenging, but I do think it positions legal teams as key partners in innovation, i.e. making sure innovation is responsible, rather than being perceived as naysayers or after the fact reviewers.
And I'm curious, I know that Jerry has worn the hat of a GC himself, and now he sees GCs from the other side of the spectrum. So Jerry, would you have any thoughts as to how you see the role evolving while we have AI, and how successful GCs can set themselves apart?
Well, I think the key thing, echoing from what we've heard from our panelists and your good self, really, is proactivity, serving as the glue and making sure that other corporate functions are sufficiently joined up so that nothing falls through the cracks. And I think it's important pretty much to set up a RACI model of responsibility, accountability, consulting, and informed so that everybody is in the picture. Because as was the case with the implementation of GDPR, it was very important to link up all these different functions. So I see a lot of back to the future planning going on in terms of implementing AI properly. I think it calls for great project management skill. I think it calls for common sense and judgment. And as was pointed out by each of you, it also calls for continuous learning and staying current. I have a question, which is a logical segue from what you put to me, Zena, which is really, should GCs, in the views of the panel, be pushing for AI governance committees or internal policies even before the act fully applies? Catherine, you want to jump in?
So I mean, we've heard from Zena that some of the obligations do already apply. So absolutely, waiting until the law is in full effect in 2026 to think about AI governance would be a mistake. AI governance is a now, not later issue. From the AI vendor perspective, we have actually seen that many of our clients have already started to set up internal AI governance committees or policies or due diligence. And these are usually comprised of, the functions that we spoke of earlier, legal, compliance, security, data privacy leads. And the committee's job seems typically to be to develop internal policies and to review AI initiatives for ethical and compliance considerations. One key advantage to this is that it allows organizations to flag potential issues. So, an apparently low risk AI use case that you're using today could potentially drift into a prohibited category or pose high risk without appropriate considerations or controls. So it's thinking for the future and thinking for right now. Forming a cross-functional AI governance group is what we've seen is quickly becoming the best practice for companies adopting AI. And it's important to consider that AI-related incidents, so say an AI tool misbehaving or biased outputs causing harm, can also happen today. So if you already have an internal policy or a committee in place, you're in a much better position to respond and remediate. I think we've seen that the Act is forcing a lot more diligence and paperwork around the use of AI tools, and it's been quite interesting to observe this from the vendor side. So we're being asked to provide detail about our algorithms, training data and controls, and otherwise helping our customers to do due diligence on their use of our AI product for compliance. But that being said, every client does seem to be different. And although admittedly it does tend to depend on the size of company or even the industry it's in. So a heavily regulated industry such as the pharma or banking industry will naturally have a more robust approach to AIGD because we often see that their compliance programs are usually more advanced. I think what the takeaway is that no one seems to have a one size fits all approach to this yet. And everyone is, from what I can tell, pretty much just learning together and trying to solve these new regulatory challenges together.
Interesting. Zena?
Thank you. Yes, I would say, risking being the boring outside lawyer, that we shouldn't underestimate the time required for preparedness. It takes a while, especially in these new waters and new territories, to build the right governance structures, to do the mapping, to find the right people. And also much of the compliance, as we've seen with sector-specific legislation like with medical devices, much of the compliance has to be inbuilt into the systems instead of being retrofitted, because that might take much longer, many more resources and time. Things like literacy take time. And so it's better to sort of get live feedback and input as you go, and starting early is key to get that input. A lot of the times we have third parties involved, and they might not all be at the same level of sophistication. So again, it will be a lengthy process to have all this back and forth and make sure we have all the right information in place, and we have identified all gaps and areas of uncertainty. Also, as a regulatory lawyer, I've seen the commission and the relevant offices that are still being set up. They're very open to discussions as to how we can make AI Act a success and we can make it work best. They don't want to be the global policeman. They want to make the EU the place for innovation. So by starting early, there is also the benefit of companies being able to engage early with the regulators and find practical solutions. And even input in guidance as we speak. So those are some additional benefits of starting early, not really waiting until the last moment.
Great. Sharik.
So, I mean, I agree, like from the vantage of the pharma industry, which is highly regulated, as you know, I think we're used to the idea that compliance and governance need to precede full regulatory enforcement. You need to start really early to make sure you're ready in time. AI, we're treating AI no differently. For us at Novartis, and this is like publicly known, like our compliance team has already sort of developed internal AI risk and compliance guidance in line with our own ethical sort of standards. And of course, in line with the international AI policies, including the EU AI Act. And we also expanded our R&D governance committee's remit to include AI oversight. And we're trying to make sure that even though all the requirements won't be enforceable until 2026, we're trying to be as proactive as possible and make sure that we're ready when everything comes into effect. From an IP angle, there's also these kind of early policies also help us manage any potential IP issues arising from AI. For example, we have guidelines, and we've had them for a very long time, to manage our partnering with the AI providers and also when we use third-party AI tools to make sure that we don't inadvertently disclose our proprietary data or run afoul of like licensing terms that we might have. And these are kind of things you can proactively address and make sure you don't have problems down the line.
Great. Thanks, Sharik. We'd now like to turn to talent readiness and the so-called AI skills gap. As recruiters, we are often asked, what is it like to future-proof your law department? Because many general counsel want us to look around the corner and say, what sort of skills are needed to ensure that the law department of tomorrow, and in fact today, is properly resourced? So I'd like to put the question to the panel. What sorts of legal and compliance skills do you see are most needed as AI regulation ramps up? How do you see legal departments preparing their talent to be ready for AI and address any so-called skills gap? Zena, would you like to jump in, and then we'll sort of go around and get some inputs from Catherine and Sharik as well?
Thank you, Jerry. Yes, I guess the starting point is read and read again and read again the applicable laws and guidance in place. It can be dense, and the more you read it, the more sense it makes in some ways. And also AI is an ecosystem of regulations. You might have the AI Act, but you also have the US executive orders, as they may change from time to time. You have sector-specific AI rules and guidance, and you have the GDPR. So really understanding the regulatory and legal landscape is key. The second point is, I think what Catherine mentioned, she is expected, or she wants to be able to understand the technologies and the terminology she's talking about. So some basic technology fluency and upskilling through training is key for lawyers who want to be involved with AI systems and increasingly be relevant. So we have black box systems and the concept of interpretable systems. What does that mean from a very fundamental perspective? How can you build data governance without understanding really the role of your training data in the model performance, but also in potential bias, and also cybersecurity awareness? So some basic terms that sound much scarier than I guess they are once you start understanding them. Another role of I guess a successful lawyer in this space, I would expect them to be people who can translate the law into practice and can embed all these obligations into product development, sit side by side with the teams, and during the product development and deployment process, be able to input and see and handle the contracts, handle the due diligence on vendors, and understand how the products can be developed compliantly. I would say investing in legal tech and legal tools is quite an important element that we see coming up. Maybe not at the moment 100% now, but definitely something that we have to live with in the future. And also just know who to ask. Don't be shy to go to your engineering teams, be that bridge, be that glue, know who to speak to get all the information you need. Because we're lawyers, we're not engineers. So there are gaps in our knowledge that we need to keep up. I think that's some high level points.
Thank you.
I think
Catherine.
thank you, Jerry. I think looking at it through the recruitment lens, we haven't had to hire new legal staff specifically for AI yet, being a smaller company. But when we do recruit, I would certainly consider candidates who show tech curiosity or experience. So a lawyer who has taken some coding classes or likes to tinker with AI tools in their free time, or has at least had experience of deploying AI within their organization. I think that attitude means they'll adapt faster to this new landscape, because it is a new landscape that we're all having to get to grips with. And I'd be interested in someone who is or could become that tech counselor that I spoke about earlier, and who would be happy to explore AI use cases within the legal team and more broadly across the business. We've realized that to effectively manage AI risk, which is a component of the legal team, our legal team must speak the language of both law and technology. So I don't mean it's not necessary for every lawyer to code or to become a data scientist, but they should be comfortable discussing things like how an algorithm reached a decision, or what training data is used, or how it's even used. And that comfort only comes from education and experience.
Yeah, I couldn't agree more, Catherine. I mean, in a larger organization, at this point, I have seen, like more recently, seen some sort of desire to hire folks specifically for AI work. And then, of course, that person needs to have some AI experience and sort of have the skills necessary. But generally, in a larger organization, the way we have started out is by designating AI leads or champions from the existing talent pool in each legal function. Because in a large organization, we have many different sort of specializations in each of the legal functions. And so, led by these AI champions, our legal and compliance teams have embarked on like a formal AI upskilling program over the past year. And like I said, more recently, in certain areas, given how many AI systems we might be deploying over the coming years, we have had discussions and actually have potentially even posted roles, I think, externally, looking for folks with the expertise who have worked on AI, particularly for this kind of deployment action.
What
Thank you,
you
Sherry.
were saying really tracks with what we did earlier. We published earlier this year our first AI survey for in-house counsel, and that survey signaled that AI fluency is imperative in hiring, retention, and business enablement. But how do legal teams build AI fluency? Sharik and Catherine, you're both in-house. Maybe you could tell us a little bit about what you're doing to build fluency in your law departments.
Sure. I think it's important to caveat that I'm not just building the AI fluency in the legal department, but across the organization. And I think, first of all, it's important to encourage an organizational culture of continuous learning. So, AI technology and regulations are evolving quickly. What you learned a year ago might be outdated next year. And I think, GCs and legal leaders can set the tone by openly learning alongside their teams and the rest of the organization. So, that there's the obvious things that lawyers can do. So attending AI law conferences, webinars such as this, subscribing to AI regulation trackers, or, doing internal lunch and learn sessions on new AI topics. I think that the worst thing that a legal team and even an organization can do is to stick their head in the sand. I think instead we need to be curious and proactive. Certainly at Protex AI, we've prioritized internal knowledge sharing and hands-on learning. I'm fortunate that I have a team of ML engineers and data scientists and data ops teams. And so who better to learn from than the in-house talent that we already have? So, it's an opportunity to actually get to learn from other teams within the organization. We even have an internal AI interest group now where employees from different departments can share updates and resources on AI. So the goal is company-wide AI enablement. And certainly what we're seeing is if somebody in a function has identified an opportunity for to automate something or to deploy AI, throw it in the channel, and somebody with expertise will jump in and help them understand how they can actually deploy it internally. So it's that continuous, feedback of internal use of people that know, teaching people that might not necessarily know. And I think, in summary, closing the AI skills gap means training your people and fostering an environment where learning about technology becomes part of the job.
Yeah, I agree, Catherine. It's very similar for me as well. Obviously in the pharma sector specifically, we face the dual challenge of understanding sophisticated AI applications like AI-driven drug discovery or diagnostic tools, and also ensuring compliance with heavy regulation. So one strategy has been, like, as you mentioned, partnering with sort of those experts, the ML experts, who we also have now hired to sort of manage our deployment of these tools on our end. So partnering with them, learning from them, because they're the ones who really know their projects, and then partnering closely with our R&D and IT departments. And then we similarly have internal AI interest groups to exchange sort of learnings around AI and have organized regular events to make sure, I think we have an AI week that's organized every year to sort of help build AI skills across the organization, not just legal. And yes, we also make it a priority to make sure that every lawyer in each of the different countries that Novartis operates in, we make sure that we share easy to understand training materials and guidance with them.
Great. Sharik, thank you. And thanks to our other panelists. We have left time for questions that we've been receiving from our audience. We'd like to tackle some of these now. Before I hand over to Pam, I just want to mention, if we don't cover all the questions that are in our chat box, please feel free to reach out to Pam or myself, and we will ensure that we arrange for a timely response. Pam, would you like to have a look at the chat room and see what's come in since our panelists have delivered the great content we've heard this afternoon?
Yeah, we have quite a few questions. One that I saw is, do you know anything about AI tools being used for internal investigations?
Any takers?
We have a lot more if you don't want to take that one.
Okay.
I do not know of any for that, but we do use AI. I have heard of AI potentially being considered to use for sort of, detecting fraud and other sort of kind of legal problems in, for example, with contracting and things like that.
Right.
What about legal versus compliance? There's an interesting question about how do you decide what's handled by compliance versus what's handled by your legal teams internally?
So at Novartis, it's interesting. We used to have a separation between compliance and legal, but more recently, our General Counsel has also become the head of compliance as well. The way we start is like compliance is, or the compliance team has sort of created the framework for how we classify the risk, and when things are not low risk, when they're a little bit higher risk than the lowest level of risk, then the legal team comes in at that point to handle those risks and make sure that they're addressed appropriately. So that's kind of how it is. It's like, the compliance team looks at it to make sure that where it fits, it gets classified, and then the legal team comes in based on the classification.
I think that's a really good separation of the roles and responsibilities. In smaller organizations, you might not have a full-blown compliance team. It might fall to legal, or some organizations might not even have in-house legal. I think it really is a bit of a balancing act between what resource do you actually have available internally. It's also that level of comfort. I think it's important, as we've mentioned about, if you feel that you're comfortable, if you think that you're fluent, if you think that this is something you can do, then maybe that's a sign for a legal team or a legal leader to wear that hat and as I said, actually become that tech counselor, and not necessarily an after the fact reviewer.
Great. Pam, could I grab one? I'd like to ask Zena this question. We've received a question that says, now that the application of these regulations has been staggered to apply at different timeframes, could you share with us which court will have jurisdiction to handle AI-related cases? Will there be a specialized court, Zena, that has some of the specialization of, say, the UPC when it comes to patent infringement? What sort of jurisdiction will be required to file AI-related suits and pleadings? Where do people go for redress?
Yes, a very good question. And it's interesting also because we used to have a proposed AI product liability directive, which has been scrapped. So at a high level, the EU AI Act will be primarily enforced at the national level by designated supervisory authorities. The European AI Office is meant to coordinate and support those authorities, but it will come down to national law. So what that means is we could really have a very sort of random piecemeal approach to enforcement, and we could even have forum shopping if some countries are harsher or more lenient than others. So in practice, what happens is that national authorities will have to monitor local deployers and providers of high-risk AI systems. They will be handling complaints and inspect workplaces. If someone wants to bring an action, it depends on where the harm, if we were talking about harm, where the harm has taken place, or where the defective AI system has been used or deployed or caused this harm. And I don't really have much faith necessarily the moment in enforcement, because existing regulatory bodies in the first instance will be used. We might have CNIL, the data privacy body, being the relevant regulator. But when we're talking about courts, we might have confusion about cross-border enforcement. So that will require cooperation mechanisms between member states. And what the supervisory authorities will accept to do or delegate to courts. So in other words, yes, we will typically expect this to fall under the jurisdiction of national courts and authorities in EU member states rather than a single EU-wide court.
Good to know.
Answers. I could get into more detail about.
That's very helpful. Thanks, Zena. Pam, would you like to choose something out of the gift box that we've received?
Sure. These are great questions. Someone wanted the team to expand on AI Act enforcement. And Zena, I think you touched on this at the top of the call when you were talking about some of the objectives.
About the enforcement?
Yeah, just how will it be enforced? Is it at the national level? What will enforcement look like insofar as you can predict the future?
Yes, no, it's another very good question and something people wonder about a lot. It will fall probably under product liability causes of action, and it will be enforced, I guess, primarily by national authorities and the competent national AI authority as coordinated by the European AI Office. We would expect, I guess, the role of the EU courts would probably be limited. What the EU courts would do would be to review the legality of the actions of those national regulators, because you have national AI enforcers and they might not make the right decision. So their decision might be appealed at EU level or hear appeals, but otherwise it would be at national level as guided by the EU AI board, European AI Office rather.
Great. I've got a question for Sharik, which I think he'll enjoy. In terms of work ownership and IPR protection, do you expect a specific regulation? And if not, do you see the tendency to interpret AI-generated work under joint ownership? How do you see that sort of panning out, Sharik?
I think that hopefully there will be some regulation and some clarity provided from government. I would hope on this aspect, but I think, generally, I don't like having AI generated work being under joint ownership. It doesn't seem to sort of make sense in our industry. We prefer to own sort of the work that is generated. I mean, that's kind of our preference. And I think we like to make sure that there is human involvement in the work that is generated, so that therefore there is a clear ownership that can be established.
So presumably the inventors still have to keep notebooks, just like the old lab days, just to make sure they have a date and a record of what they...
I think, yes, documentation of human involvement is very important.
Good to know, because I guess there have been court cases, have there not, that said you can't have AI.
Exactly. As a patent attorney, that's kind of something I'm very mindful of.
That's interesting. That's great. Here's a question for the group. This is a very futuristic question. Someone asked, will legal departments of the future still be composed of lawyers and paralegals only, or do you see it shifting mostly to become mostly through AI technicians? So what might the composition be? Sharad, do you want
I can take that. So I can take that. So I think we will always have lawyers and paralegals. I mean, maybe not always. Okay, I can take that back. Maybe for at least the next 10 years, I'd say we'll have lawyers and paralegals. Where I see the law departments of the future going is that we will have, and we've already sort of started doing this, is we will have legal innovation as a part of the legal function. And those are the folks who may not be lawyers, or maybe there are former lawyers who are now like sort of have shifted into a new function where they are helping us deploy AI and, like I said, legal innovation, as you can tell from the name, helping us sort of make our processes more automated and saving time. So there will be lawyers and paralegals, just a lot fewer of them. And yes, there will be sort of, we can call them AI technicians if you want, but people who are innovators in the legal field who are working with the legal team to make sure that any issues that we come up with that should be automated are automated, and then there are savings from that.
Is that kind of turbocharged legal ops for the benefit of the audience?
It is. Legal ops is part of legal innovation, but legal innovation, they also have folks who are focusing on AI specifically. So yes, legal operations has been sort of put into that bucket as well, but it's not legal operations alone. It's more than that. And so they are working with us directly. As an example, I think either Zenobia or Catherine mentioned earlier, like, we encourage people to come up with problems or, processes they think can be automated. And then we work with the legal innovation team to make sure that, either we already have a tool that can be sort of changed to fit that need, or even if we start from scratch to build the tool, we provide the right sort of team to build that.
Any hallucinations yet?
Those are always a problem. That is something. I mean, obviously, with any AI deployment, you always should make sure that there is a human check at the end of it, particularly for legal functions.
There you go. I'm sorry, Catherine, you had a point.
Yeah, Catherine.
Yeah. No, I mean, just to echo all of that, but I think it was quite a nice segue, because what I was going to say is, I think until we can find a way to measure the accuracy of AI use case models, there is always going to require that human oversight, that legal check. And so, I think one really classic example might be, let's say that as a vendor, I have customer paper pushed on me. The definitions do not match at all. It messes up my warranty provisions. It messes up my standard IP. It messes up my standard, indemnity provisions. An AI system today would likely say, this is Catherine's standard position. Let's overlay it. Let's introduce all of this red line. That is never going to get you very far. Trying to close a deal quickly, trying to reduce sales cycle time. So like it just doesn't work. And so what you need, which still remains a human skill, is that ability to just, put surgical incisions in where you can, and sort of, maybe adopt a 60-40 as opposed to 80-20 risk profile, and just kind of, make that human decision. And right now, an AI tool doesn't have that capability. And I think you're always still going to need some, a human oversight that can apply, the business sense, but also the accuracy and the verification check.
Interesting. Pam?
This is a great conversation, and these questions are fantastic. Someone just wanted to know, what are more examples? Because Catherine, you shared some of these in your answer about high-risk cases versus low-risk use cases. How can we help people differentiate and think about some examples?
So the EU AI Act itself has an Annex 3 that lists prohibited use cases to start with. There's also Annex 3 also has the high risk AI use cases. So you can actually go and look at the Act itself, and it will actually help you immediately identify prohibited and high risk. And then Zena, I feel like I saw on one of your earlier slides that you did have some examples, or maybe I've seen you give other presentations where you've had various slides of this, but maybe you could talk through some of the lower risk and the medium risks.
Thank you. Yeah, so basically, if you have, there are examples of chatbots, for example, or AI suggesting optimal email marketing times. All these sort of very standard uses are low risk. They're minimal risk AI systems. They're not really. They're typical consumer facing. They're not used for sensitive functions. So those would be minimal risk. Limited risk is somewhere in between. So if you have AI generated deep fakes, if you have AI virtual assistants, those might be limited risk. And then high risk systems are defined as falling under specific categories. So that would be education, healthcare, law enforcement, financial services, employment and human resources, critical infrastructure and border control. And we had one of those questions in the chat about border control and facial recognition. All those systems might pose significant risks to fundamental rights. They might, I am a healthcare lawyer, so systems that might provide some sort of diagnosis, for example, has a direct impact to health. Anything that might impact access to employment, and those categories would most likely be high risk, as opposed to AI used, cosmetically, like photo filter apps and things like that. But yeah, Catherine exactly spotted the annex in the regulation that talks about those use cases, and I'm sure we'll have more guidance with time that mentions specific gray area examples.
Great. I think we have time for one more question. Pam, do you want to take a shot at this? Should we go for the
I
sandbox?
want to end this in a positive way, because there can be this tendency to say, like, this is scary, or we're not going to have a job tomorrow, or we're all going to get fined 7%. What are the qualities that will differentiate lawyers in the world of AI?
I think an openness to learning. I think that's the bottom line. If you're willing to learn, I think you will do great in the AI. If you're not afraid of something that seems complicated and you have faith in your ability to figure it out, I think you'll do well.
I think that's a really, really great one. I think also not being afraid to spot efficiencies within what you're doing today and finding ways to automate. One example is I've done a self-service NDA that just someone fills out a form, automatically generates an NDA, and I never have to touch an NDA again, unless red lines come in, but usually they don't. And I have it tracked. Every single NDA that's come through is tracked. And I don't find that scary. I think that saved me a lot of time. So I think it's just, it's being able to spot things which take up a lot of time of your day, that if you could just move that off your plate and get some space to think about other things, or more impactful things, I think that's only good.
Excellent.
Spot on. I guess I would echo exactly what Sharik and Catherine have said. And I guess another element to it is pulling teams together. You're not just the lawyer doing ABC. You now have to sit with HR, marketing, engineers, expand the way you approach your work, and really do the more interesting work, and maybe delegate some of the more mundane day-to-day tasks to AI. It's a shame that might now be a paralegal. The paralegal in the future will do more maybe elevated functions and more learning. I think even today, compared to 20 years ago, we don't have to spend 5 hours typing and manually inputting the track changes to a document. It saves us time. So I want to think of it in this way.
Interesting, Zena. I could see upgrading the paralegal role to a knowledge management function, almost like a PSL. So at the moment, many large law firms have professional service lawyers, and we could actually see the ennoblement of the paralegal such that these contract precedents are being kept up to date and made even more sophisticated as a result of the experience collectively of the law department or the law firm in which they work. So that's pretty interesting stuff. Pam, would you like to sum up? I'll say my thanks now, and I'll let you chime in.
Sure. What a nice conversation. Just a huge thank you to our incredible panel for sharing your expertise, and to the several hundred of you who joined or tuned in from around the world. You are, by being here, you're ahead of the curve. So congrats to you. And I hope this is just the beginning of the conversation. If you have questions, if you want to dive deeper, if you're thinking about hiring AI talent to support your legal team, we're here and we'd love to help you. So thanks again for spending some time with us.
Yeah. Thank you all, guys, and have a great rest of your day. Thanks a lot.
Thank
all
you.
the best.
Thank you so
Bye-bye.
much for having us in the great discussion today.
Thank you, Zena. Thanks, Catherine. Thanks,
Thank you.
Pam.